Welcome back to Lost Dash Channel. My name is Anton Bieltsin. I'm an attorney in the Southern District of California here in San Diego. If you remember in 2017, it seemed like overnight e-scooters, or those electronic dockless scooters, took over our streets. All over the United States, in most major cities, companies like Bird, Lyft, Lime, all had e-scooters, those electronic dockless scooters. Now, the city of Los Angeles adopted a permitting program whereas they would require these companies to provide real-time data to the city on the location of each of these scooters in case they needed to take the scooter out of the public way if it was in the way of sidewalks and so on. Now, a particular individual sues the Transportation Division of the City of Los Angeles, saying that this is a search in violation of the Fourth Amendment. And before we talk about the Fourth Amendment and whether this is actually a search by the government, I want to thank you for watching me on YouTube. And if you're listening to the podcast version of this recording, please give it a 5-star review rating. And finally, if you want to support this channel, go on lostdash.com and purchase one of these t-shirts. Thanks for watching.
Quick message from Lost Dash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Bieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Lost Dash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Lost Dash YouTube page. That's LAWSTACHE.
Today we'll be discussing a 2022 Ninth Circuit case, Justin Sanchez versus the City of Los Angeles Department of Transportation. As you've heard in my introduction, roughly in 2018, the City of Los Angeles adopted a permitting program requiring e-scooter companies like Lime and Bird to provide real-time data on location of each of their scooters to the City of Los Angeles. Mr. Sanchez rides these scooters to work, back to his house, and so on. He sues the city, saying that this is a violation of the Fourth Amendment because this is an illegal search, because the company provides real data of the location to the city. Now, the Fourth Amendment protects you against unreasonable searches and seizures. And before we discuss whether the search is a reasonable one, the initial question has to be whether this is even a search under the Fourth Amendment. Now, for much of our nation's history, a search under the Fourth Amendment was defined by the common law trespass theory, meaning if the government physically intruded into your property, that was deemed a search. But then the Supreme Court Katz reminded us that the Fourth Amendment protects people, not places. And thus a new test was developed called reasonable expectation of privacy. Under that test, we have to look whether the person has an expectation of privacy, a subjective one, and whether that expectation is one that the society is ready to accept as a reasonable one. Now, this case takes us into two line of cases. One, whether this is a reasonable expectation of privacy for Mr. Sanchez to think that this location would not be shared with the government. And then the second line of tests, or in cases, really deals with what's called a third-party doctrine, meaning what information you keep to yourself and what information you share with others. And so the court goes on and discusses both lines of cases. In the first line of cases, the Ninth Circuit discusses all of the developments in the Supreme Court since the case Katz. We're talking about the reasonable expectation of privacy arena. And here are the cases. The Ninth Circuit talks about Knotts, which was a case where the government put a GPS beeper into a container that was later placed in the defendant's vehicle, and the government tracked that vehicle using that beeper. Of course, you really need to read the case in order to understand what we're even talking about. What are GPS beepers and how are they different from GPS that we know of today that works through satellite. Then the second case was Jones. This is the case I've discussed previously on this channel, where the government installs a GPS tracking device on the vehicle, and the Supreme Court says that this was a search in itself because the information that would later be shared, the person would have a reasonable expectation of privacy. But not only that, the court focused on the trespass theory, meaning that the second the government installs a GPS tracking device on the vehicle, that is a search, period. And finally, the third case is Carpenter, that dealt with the historic cell site location information that's shared with the government. The Ninth Circuit really doesn't make any conclusions when it goes through all of these cases, and eventually just moves on to the third-party doctrine. Under this doctrine, a person does not have a legitimate expectation of privacy in the information he voluntarily turns over to a third party. And so the Ninth Circuit continues to discuss all the Supreme Court cases that dealt with this line of cases. In Miller, investigating tax evasion, the government subpoenaed the defendant's banks, seeking canceled checks, deposit slips, and monthly statements. The court held that the checks were not confidential communications, but negotiable instruments to be used in commercial transactions. And the bank's statements were exposed to bank's employees in the ordinary course of business, having taken the risk in revealing his affairs to another, that the information would be conveyed by that person to the government. Miller's purported expectation of privacy were unavailing. And then moving on to Smith, the court applied similar principles. The court held that the government's use of pen register, which records the phone number dialed on a landline, was not a search. In so ruling, the court noted its doubt that the people in general entertain any actual expectation of privacy in numbers they dial. And the Ninth Circuit also cited a case that is more similar to the eScooter situation. In Azam, the third-party doctrine has also been cited to explain why neither the taxicab driver nor passengers have a reasonable expectation of privacy in the pickup and drop-off data collected by the GPS tracking aspect of a taxicab meters. There has been some criticism of the third-party doctrine. For instance, Justice Sotomayor has noted that the assumption of risk rationale underlying the doctrine is ill-suited for the digital age, in which people reveal a great deal of information about themselves to third parties in the course of carrying out mundane tasks. And then there is Justice Gorsuch, who in his dissenting opinion in Carpenter noted that even our most private documents, those that in other eras we would have locked safely in a desk drawer or destroyed, now reside on third-party servers. And the case Smith teaches that the police can review all of this material on the theory that no one reasonably expects any of it will be kept private. But no one really believes that, if they ever did. At the end, the Ninth Circuit says that because the third-party doctrine squarely applies to Sanchez's voluntary agreement to provide his location information to the eScooter operators, who then give that information to the city, that is not a search under the Fourth Amendment, and thus his Fourth Amendment rights are not violated. If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know. And if you're listening to the podcast version of this recording, please give my podcast a 5-star review rating. And finally, if you want to support this channel, check out my website at lostdash.com, where I sell this design of my t-shirt with a Padre, and of course my more famous Do Not Arrest This Person t-shirts. Thanks for watching.